That's all right, Betty. How about a little kiss?
The first time anyone ever published the words sexual harassment wasn't until 1975.
When I was in the workplace in the 60s before becoming an attorney, I just knew that sexual harassment was something that women were suffering in the workplace, but I didn't know anyone who was doing anything about it because they didn't know that they had a right to do anything about it, and for a long time they didn't have any right to do anything about it.
Since then, we've gone from this
Behave yourself, Mr. Bond.
to this.
Professor, do you swear to tell the whole truth and nothing but the truth, so help you God?
I do.
I deny each and every single allegation against me today.
And more recently, this.
The list goes on and on of famous, powerful men who've lost their jobs recently because of allegations of sexual misconduct in the workplace.
I don't even wait. And when you're a star, they let you do it. You can do anything.
Whatever you want.
Grab them by the
Raise your right hand and repeat after me.
Well, I think what we have is evolution rather than revolution.
We sat down with a pioneer in the women's rights movement to talk about where we are in that evolution.
This entire year has been the winter of our discontent, but it has also been the year of our awakening, and awake we are.
We also asked her about the more controversial parts of her approach.
A jury awarded her more than $4 million in damage,
like secret settlements and eye-popping payouts that she says are essential, but that have earned her many critics.
Of course, I believe in the cause of women's rights and to be able to have a workplace free of sexual harassment. I will take the heat from people who want to criticize me for helping women to enter into settlements. But it is not my job to sacrifice my clients to a cause, even a cause to which I firmly believe and for which I have advocated my entire life.
Even in the wake of the Me Too movement, when thousands of women and some men went public with stories of abuse, the disillusionment can be very real.
For younger women especially, they are even more disappointed than women of my generation because they actually expect to be treated equally and to be free of sexual harassment.
First of all, what constitutes sexual harassment?
What is sexual harassment? I didn't know if that was harassment.
What do you think you're doing?
One we call hostile work environment. The other is quid pro quo.
Sexual harassment is what the courts say it is. And that has been evolving over the years. I do think that later there became a cultural definition that may not be the same as the legal definition.
Me Too and the Time's Up movements are getting more complicated.
Now we're heading into this territory where I feel like the goalposts are being moved.
And somewhere in between those legal and cultural definitions sits the corporate approach and the harassment training videos we've become so familiar with.
Did I do that? Oh, I am sorry.
It's nothing, don't bother. If he doesn't stop, I'll scream.
But as long as harassment is still a problem, Gloria believes non-disclosure agreements, or NDAs, should continue to play a role for victims.
They never told their mother or their sister or their dad or their husband or their brother or their kids about it, and they don't want them to know. And they don't want the community to know for fear that that might hurt them in getting their next job.
Are you going to protect yourselves and your futures?
But that puts her at odds with many advocates fighting gender-based harassment and assault as a systemic issue. They warn that NDAs enable bad behavior by keeping it secret.
Maybe they didn't like the joke I told. And let me put.
Each time it happens, he puts a chunk of money on the table and then forces the woman to agree to wear a muzzle for the rest of her life.
There are politicians who grandstand and now are in progress of limiting women's rights, limiting settlements that might have confidentiality clauses.
When the state of California outlawed settlements that would keep victims silent on felony sex offenses, many saw it as a leap forward. Not Gloria.
Their choice has been taken away from them by the accused sexual predator. They might be able to obtain millions of dollars to help them to go on with their lives. Victims should have a choice.
She says it's companies that need to take more responsibility.
It's not enough to train your employees not to sexually harass. It's important for businesses also to monitor their workplaces. And that's sometimes where it all breaks down.
By 1980, when Dolly Parton's 9 to 5 hit theaters,
I put up with all your pinching and staring and chasing me around the desk because I need this job, but this is the last straw.
there was a name for this kind of behavior. A few years later, the courts began to give it a legal framework.
The Meritor case was 1986, which is really considered the landmark case.
Michelle Vinson sued the bank where she worked, saying she'd been repeatedly harassed and raped by her supervisor. Sexual harassment was not considered an illegal form of workplace discrimination under any U.S. law, at least not yet.
They laid out, in a sense, a blueprint, guidance through their opinion about what is necessary to prove sexual harassment.
A new idea was starting to gain traction. Unwanted, pervasive behavior based on someone's gender could be a violation of their civil rights.
Judge, would you stand to be sworn?
5 years later, another milestone, the 1991 confirmation hearings of Clarence Thomas.
At that hearing, which, by the way, was chaired by Senator Biden,
I do.
Thank you.
Anita Hill testified that Clarence Thomas sexually harassed her when he was her supervisor.
He spoke about acts that he had seen in pornographic films involving such matters as women having sex with animals.
I deny that I had conversations of a sexual nature with Anita Hill.
That's when the country really focused on what is sexual harassment in the workplace. Does it matter? Here, what we had was Clarence Thomas being elevated, essentially promoted to a new job.
So help me God.
Becoming a justice on the United States Supreme Court. The country learned that even though it exists, sexual harassment in the workplace doesn't seem to be a penalty for it, at least not in the political world.
But corporate America was listening. By 1997, according to the Harvard Business Review, 3/4 of American companies had some kind of mandatory harassment training in place.
It makes it easier if you just kind of chuckle at their stupid little jokes, or if you pretend not to notice the way their eyes wander around you. Now they call it sexual harassment. Hell, it happens so much, I used to call it going to work.
Then, decades later, another famous example of a Supreme Court judge confirmed despite testimony that riveted the nation.
Brett groped me and tried to take off my clothes. I believed he was going to rape me.
Nominated by a president who has been publicly accused by dozens of women.
He then grabbed my shoulder and began kissing me again very aggressively and placed his hand on my breast.
So many women have come forward and alleged that they were sexually assaulted by him. But of course, Trump seemed to be rewarded for that.
The office of President of the United States.
But in this case of President Trump, it's had both legal and political consequences and cultural consequences. So it's really been a teaching moment. We are going to resist. We are going to insist. We are going to persist.
Starting in 2017, a litany of powerful men have been pulled from their perches. One in particular proved complicated for Gloria when news surfaced that her law firm had drawn up many of the NDA settlements that had kept allegations against Harvey Weinstein out of the public view for many years. Ashley Mathau, one of the victims who'd been represented by Gloria's firm, later criticized this approach when talking to the New York Times.
Harvey offered like a $125,000 settlement. They, wanted me to talk about Harvey in like a good light, and he was a great person to work for. Now knowing what I know, I don't think they're right. I think it makes the assaulter able to do it to other people and hide it.
It appears to me that Mr. Weinstein's public relations machine is working overtime.
Many women's rights advocates were furious, but Gloria insists that she did not silence women.
Even though some victims entered into settlement agreements with Mr. Weinstein. And even though there might have been non-disclosure agreements, they had a right to go to the police and file a police report and to ask that criminal charges be brought about what happened to them.
Her critics also point to the massive sums she often wins for her clients.
You think some of them are lying?
Absolutely.
Really?
Wherever you see Gloria Allred, you know somebody's lying.
But according to Gloria, hefty financial penalties can make a difference.
Last year, our law firm won the largest verdict for one victim of sexual harassment. We won for our client $58,250,000.
Women like Ms. Khan are no longer willing to suffer in silence. Employers now have more than 58 million reasons to take action to make sure that their workplace is free of sexual harassment.
That case has inspired many victims of sexual harassment to contact us. This is part of the evolution of the Me Too movement.
At the end of our interview, I came back to the question of whether victims should be encouraged to speak out rather than kept silent. I told her that I still feel guilty for keeping quiet after an incident that happened to me decades ago.
Well, I'm not a person who believes that guilt is something that should be imposed on victims. They don't have a legal responsibility to go public. I don't believe they have a moral responsibility to sacrifice their privacy and go public. Their obligation is to act in their own self-interest.